Good morning, everyone. Welcome to our panel on the international law, on the law of the sea, which is part of the symposium, which marks the 50th anniversary of the Faculty of Law at the University of the West Indies. This afternoon, we have a strong panel to discuss matters concerning today's law of the sea. And I think this is a very appropriate panel for us to have. And I'm grateful to the faculty for including this panel for our consideration. The faculty has had a strong tradition of international law, and this fits nicely within that tradition. It should also be recalled, of course, that Jamaica houses the headquarters of the International Seabed Authority, so that lends a certain degree of topicality to what we are considering today. Today, we will be looking at 4 aspects of the law of the sea, and we have 4 distinguished panelists to guide us. First of all, in order of presentations, we have Judge Kathy Ann Brown, who is a Jamaican national. We have Dr. Martins Paparinsky, who is based at the University College London. We have Dr. David Berry, who is a former dean of the Faculty of Law at Cave Hill. And we have Professor Robert Volterra, who is a practitioner and is associated as a professor with the University College London. So those are our 4 panelists. I would like to apologize to them for our slightly late start, but that was because we are in the stream of a backlog, a very important backlog. There was an exciting discussion about ethics and primarily judicial ethics this morning. So now we should begin our panel. And our first speaker will be Judge Kathy Ann Brown. And Judge Brown will be talking on the topic dispute settlement under Part 15 of the Law of the Sea Convention. Judge Kathy Ann Brown was elected to the International Tribunal on the Law of the Sea last year. Prior to her election, she served as Jamaica's permanent representative to the International Seabed Authority. She has worked for the Jamaican government and various international institutions in Europe in a number of important high-ranking capacities. One includes the position of Deputy Solicitor General of Jamaica. Dr. Brown has also been a lecturer in the Faculty of Law, UWI Cave Hill, and more recently in the Faculty of Law, UWI Mona. We look forward to hearing Judge Brown's contribution on dispute settlement under Part 15 of the Law of the Sea Convention. Judge Brown, I turn it over to you.
The question I ask myself and you is, to what extent may general principles of law, okay, sorry, I'm just trying to fix up the computer. This is, I hope all this time is erased from my time, this Professor Bassiani. The question I ask myself and you is, to what extent may general principles that to a greater or lesser extent have been embraced by international law, such as the res judicata and lis pendens, limit this practice? The requirements of res judicata and lis pendens are largely the same. The triple identity test requiring the same cause of action, parties, and the object of the dispute applies to both principles. Though conceptually similar, Lis pendens applies when the competing proceedings are ongoing. Res judicata in contract relates to the binding and preclusive effects of completed proceedings. The ICJ has stated that res judicata is a principle of customary international law. However, the ICJ's application of the principle in the second maritime delimitation case between Nicaragua and Colombia concerning the outer continental shelf is a matter of some controversy. The court was evenly split on the issue of res judicata. The decision of the majority relying on the casting vote of the president of the ICJ. In rejecting the application of res judicata, the majority observed that it is not sufficient for the application of res judicata to identify the case at issue, characterized by the same parties, object, and legal ground. It is also necessary to ascertain the content of the decision, the finality of which is to be guaranteed. The majority's clarification of the application of res judicata principle suggests that a deeper comparative analysis is merited. That is one that examines the content of the decision to see whether the matter before the court was fully addressed in the previous proceedings. This is pertinent to our discussion on the Chagas Island cases, which I hope to get to in a moment. Another matter which is pertinent to that discussion is that the res judicata principle does not apply to a decision on a preliminary objection. As explained in the 1962 Southwest Africa judgment, decisions on an interlocutory character cannot prejudge questions of merits. This question was raised for the first time in the Tideman case before the Polish-German Mixed Arbitral Tribunal. The tribunal explained that should a tribunal in a preliminary judgment rule that it has jurisdiction, and subsequently, but prior to the judgment on the merits, decide that in fact lacks jurisdiction, it may and indeed must reverse itself. To remain faithful to the res judicata principle and continue to hear a case, even when it becomes clear that a tribunal, contrary to its initial ruling, in fact lacks jurisdiction, would amount to an abuse of authority. There are several cases one could discuss in assessing the growing use of multiple fora in resolving disputes, but given time limitations, I will limit my remarks to one cluster of cases, and that cluster is the Chagas Islands cases. In the Chagas Islands disputes, there are three principal cases that are of relevance. You have the 2020 ongoing case before the International Tribunal of the Law of the Sea Special Chamber between Mauritius and Maldives to delimit the maritime areas. Then there was the February 2019 ICJ advisory opinion on self-determination of the Chagas. And there was a 2015 UNCLOS, that's 1982 Law of the Sea Convention, Annex 7 arbitration between Mauritius and UK on the Chagas Marine Protected Area. The ITLA Special Chamber judgment on its jurisdiction was given in January 2021, and the case is now in the merits phase. As noted, the res judicata principle will not apply to this recent judgment, as it is a decision on a preliminary objection, but it would apply to the 2015 Chagas Annex 7 decision as regards matters determined between the UK and Mauritius. But what of the 2019 ICJ opinion? Res judicata is a Latin term for a matter decided. May a non-binding advisory opinion effectively settle a matter, that is to say, be determinative. Now, what is ongoing in this current challenge that is between Mauritius and Maldives in the delimitation of their maritime areas? The Maldives raised 5 preliminary objections to the jurisdiction of the special chamber. The argumentation concerning 2 of these meant that the ITLA special chamber had to consider the implications of the ICJ advisory opinion and the Annex 7 tribunal decision in its ruling on its own jurisdiction. Maldives' first 2 preliminary objections. The first one asserted that the UK was an indispensable third party to the proceedings, and therefore the chamber had no jurisdiction over the alleged dispute because UK wasn't present. The second submitted that the special chamber had no jurisdiction to determine the disputed issue of sovereignty over the Chagas Islands, which should be a prerequisite to determining Mauritius' claims to maritime areas. If the UK had legal rights in the maritime areas of the Chagas Islands as ostensibly decided in the 2015 Annex 7 tribunal case, it would be an indispensable third party in the proceedings. As both the UK and Mauritius claim sovereignty over the Chagas Islands, there ostensibly is a sovereignty dispute. But was this settled by the ICJ advisory opinion in 2019? Maldives asserted that the ICJ advisory opinion is non-binding and of no consequence. And moreover, the ICJ advisory opinion could not overrule the 2015 Annex 7 tribunal decision. The Itlas Chamber has rejected Maldives' objections to its jurisdiction. And a few facts help us put this in context. So that's a map of Mauritius and Maldives. They are states consisting of several islands in the Indian Ocean. Mauritius claims the Chagas Islands as part of its territory. France ceded Mauritius and its dependencies to the UK in 1814, and the UK administered the Chagas as a dependency of the colony of Mauritius. But in 1965, the UK agreed to the independence of Mauritius, conditional on Mauritius agreeing to the detachment of the Chagas so that the UK and US could establish a military base. The Premier of the Mauritius, under pressure, went along, but he did secure some concessions regarding fishing rights and mineral resources and the eventual return of the islands when the military base was no longer needed. This is referred to as the 1965 agreement, the Lancaster House Undertakings. The UK then established the Chagas as a separate colony known as the Biot, British Indian Ocean Territory. UK's actions were condemned by the UN General Assembly, and in 1968, Mauritius became an independent state, and for the past 40 years, Mauritius has consistently objected to the UK presence in the Chagas. Now, the map that you're now seeing is an MPA, a marine protected area that the UK declared in April 2018 around the Chagas Islands, or the Biot, as the UK calls it. The MPA essentially banned all fishing, marine protected area. Mauritius protested, and in December 2010, they initiated UNCLOS Annex 7 proceedings.
Judge Brown, I don't know about others.
Professor Bassiani?
I was saying that I was having a challenge hearing you, but maybe it's my internet connection.
No, well, I will slow down. Maybe that I speak a bit quickly, but I will slow down, and maybe
no,
that.
No, it's not this, not the pace of your speaking. Go ahead.
It's okay. You know what? I can put on a microphone, so that might assist to make it clearer. I will use a microphone if that assists.
I'm now hearing you very clearly.
Okay, so I don't need the microphone. You're okay.
I don't think so.
Okay, all right. So okay, so in 2010, the UK declared this marine protected area. Mauritius challenged it, and the jurisdiction of an Annex 7 tribunal, which is under the UNCLOS, the 1982 Law of the Sea Convention, is to interpret the convention. So Mauritius framed the dispute, at least those in its first two submissions, as one concerning the definition of the coastal state in the UNCLOS, arguing that it and not the UK was entitled to exercise the rights of the coastal state. The Annex 7 tribunal, however, found that the dispute was in fact a sovereignty dispute and that it lacked jurisdiction to entertain Mauritius's first two submissions. Two of the five arbitrators dissented, and for them the central issue was whether the excision of Chagas was contrary to legal principles of decolonization and self-determination, which they felt the tribunal was competent to examine as a supplementary question in settling the dispute. Given what I've said thus far, one may reasonably conclude that the legitimacy of the UK's continued administration of the Biot, or the Chagas, and the issue of which state is entitled to exercise the rights of the coastal state was not determined by the Annex 7 tribunal, or was it? You remember that the issue of res judicata, as clarified by the ICJ in the Nicaragua-Colombia case, is that it is necessary to ascertain the content of the decision, the finality of which is to be guaranteed. So what did the 2015 Annex 7 Tribunal decide? Although refusing to address Mauritius's claims on the definition of the term coastal state, the Annex 7 Tribunal did not rule on the UK's actions in establishing an MPA. In finding that the UK breached its obligations under UNCLOS in establishing the MPA surrounding the Chagas, the Annex 7 upheld the undertakings in the Lancaster House, and the tribunal ruled what you see there on the screen. It ruled that Mauritius enjoyed rights to fish in the waters of the Chagas Islands, subject to licenses issued freely by the UK BIA administration, but dependent on the overarching defense needs of the US and the UK. It also decided that the UK was under a legal obligation to return the Chagas to Mauritius when it no longer needed it for defense purposes. And it also decided that the UK was to preserve the benefits of minerals, etc. Under the UNCLOS Law of the Sea Convention, the right to manage the living and non-living resources of the adjacent seas belongs to the coastal state. So was the tribunal in fact acknowledging that the UK is the coastal state? It would seem that the regime providing for the UK to issue licenses, etc., as laid out in the dispositive, that is the operative provisions of the judgment, would be res judicata. But the special chamber in its 2021 ruling did not accept the Maldives claim that the tribunal determined with res judicata effect the regime between Mauritius and the UK. The UK, this is entitled, they did not accept that the UK is entitled to exercise the rights of the coastal state. The special chamber noted that the arbitral tribunal was without prejudice to the question of sovereignty. But isn't what is in the dispositive determinative? Maldives also challenged that the ICJ advisory opinion could not overrule the 2015 decision. The special chambers explained that there can be no question of the ICJ advisory opinion overruling the award because the issues were different. But what did the ICJ advisory opinion decide? The advisory opinion essentially decided that the UK's continued administration of the Chagas is unlawful and that it must be brought to an end as rapidly as possible. When this came to the attention of the General Assembly, the General Assembly affirmed Mauritius, that Chagas is an integral part of the Mauritius territory, and they called on the UK to withdraw within no more than 6 months. How did all of this come together in the ongoing proceedings before the special chambers? The special chamber decided that it was competent to look at the ICJ advisory opinion to the extent necessary to determine its jurisdiction. And it stated that judicial determinations made in advisory opinions carry no less weight and authority than those in judgments because they are made with the same rigor and scrutiny by the principal judicial organ of the United Nations with competence in matters of international law. The lack of the UK's consent to the ICJ's advisory proceedings did not mean that the advisory opinion could not entail implications for the disputed issue of sovereignty. The special chambers found that the UK's claim to sovereignty over the Chagas is contrary to the ICJ advisory opinion, and that the ICJ advisory opinion can be interpreted as suggesting Mauritius' sovereignty over the Chagas. Therefore, the UK's claim to sovereignty was nothing more than a mere assertion, which does not entitle it to be viewed as an indispensable third party. And in fact, it regarded that Mauritius can be regarded as a coastal state for the purposes of the maritime delimitation proceedings that are to take place. And what are the reflections on that case, because what are the implications of the IC advisory opinion? Mauritius pushed for this advisory opinion. Mauritius initiated 2 cases, one against the UK and now against Maldives. If one accepts that the ICJ is qualified to make an authoritative assessment of what the law is, and I believe that we all accept this, does it not follow that authoritative assessment has a legal effect? So the claim made by a state to the contrary must be rejected? The decision of the special chambers appears to suggest that the ICJ's Chagas advisory opinion has determinatively solved the sovereignty dispute. The ICJ emphasized the erga omnes nature of the obligation to respect self-determination. An obligation, erga omnes, is one that is owed to the entire international community. The legal effect of such a characterization is the generation of procedural right of standing on the part of all states to invoke the responsibility of a state that is in breach of its obligation. This does not mean that a state must cooperate to complete the decolonization of Mauritius, but it does suggest that a state could refuse to recognize a claim, such as that of the UK, that is in breach of what the ICJ says is an erga omnes obligation. Is this not what the special chamber did by saying that UK's claim is now merely an assertion that doesn't provide it with sufficient interest to be seen as an indispensable third party? Had the special chamber recognized the UK as an indispensable third party, would it not seem to have totally disregarded the ICJ's advisory opinion? A case not totally dissimilar to the Mauritius Maldives case is 1995 East Timor case, where the ICJ upheld Australia's objection that Indonesia was an indispensable third party. And the most critical distinction between that 1995 case and the Mauritius Maldives case would seem to be the authoritative statement of the law in the form of an ICJ advisory opinion, which may have been said to already have solved the sovereignty dispute. The special chambers has interpreted the ICJ advisory opinion as, quote unquote, suggesting Mauritius' sovereignty over the Chagas archipelago. But was this suggestion sufficiently determinative? Let us take this one step further. How does the ICJ advisory opinion affect the decision of the Annex 7 Arbitral Tribunal? Is this decision effectively nullified, thereby altering the rights or obligations of the UK and Mauritius as stated therein? The Chagas MPA arbitration provides for a regime where the UK continues to act as the administering power over the Chagas, issuing licenses to Mauritius to fish until the territory is no longer required for defense purposes. It's final and without appeal. That decision, according to the UNCLOS, must be complied with by the parties. There's no provision for revision, which in any case would be inapplicable. So is the 2015 judgment still binding on Mauritius? Must Mauritius limit its fishing to whatever licenses may be issued by the UK? Mauritius' strategic pursuit of its claim to the Chagas before 3 legal bodies has reaped significant success for it, in that it could be stated that Mauritius' objective has always been to secure acknowledgement on the international stage of its claim to the Chagas. The Mauritius has actually gone a step further and is now arguing for UK representation of the BIAT on various bodies, such as the Regional Fisheries Management Organization in the Indian Ocean, to be removed, given the implication of the ICJ advisory opinion and this 2021 Special Chambers decision. And it's a strategic use of international dispute settlement mechanisms, which is to be, I think, congratulated. There are several other examples which I wanted to go through, but I decided that it was better to try to do one in depth than 5 in a bit more, five in a bit less less depth. So I apologize for the problem with the computers. Unfortunately, I tend to be very non-paper. I'm a paperless, which means that my notes are on the same computer that I am participating in this with. So apologies, and I'm sorry.
Thank you very much, Judge Brown. You have taken us through, notwithstanding the computer challenges, you have taken us through a fairly technical set of issues, which also carry significant policy questions with them. And I look forward to the question and answer session, which I hope you'll be able to attend, and we'll raise some issues arising from your presentation. So thank you very much for that very enlightening presentation, primarily on the Chagas Islands litigation. Thanks again. I'd like to move now to our second speaker, who is Dr. Martins Paparinskis, and he will be speaking on the topic sea level rise issues in international law. Sea level rise issues in international law. Dr. Martins Paparinskis is reader in public international law at University College London. He is a co-editor of Current Legal Problems and a member of the UCL Press Editorial Board. Martins is a member of the Permanent Court of Arbitration, the OSCE Court of Conciliation and Arbitration, and the Implementation Committee of the UNECE Water Convention. He's also a candidate co-nominated by Latvia, Estonia, and Lithuania for election to the International Law Commission in 2021. So as we welcome Dr. Paparinskis, we take the opportunity to wish him well in his election campaign for the International Law Commission. Dr. Paparinskis, the floor is yours.
Many thanks, Professor Vassiani, for the very kind and generous words of introduction. Many thanks indeed for the organizers for having me, and to Odessa Coates for impeccable organizational efforts. Let me now bring up my slides. I hope that they are all in order. For those watching, I think that there should be now the opening slide. Right, so the topic that I want to address is sea level rise in relation to international law. A rather broad topic that I propose to address in 4 steps in line with this outline. And as the outline does not really hide, the thrust of my presentation will be regarding the 3rd point, and the 1st and the 4th point will be touched rather briefly. I will make 4 points. First, I will introduce the problematique and say something about the politics and science of the challenge. Secondly, I will say something about the techniques and fora that international law provides for addressing sea level rise in relation to international law. The core of my presentation will be in part 3, where I will speak about sea level rise in relation to law of the sea. Now, as those of you who follow this topic may appreciate, this choice trails the approach taken by the International Law Commission, which has created a study group on sea level rise in relation to law of the sea. And the first issue's paper was addressing precisely law of the sea. And these are the issues that were identified by the co-chairs of the study group. So I propose to reflect on these issues, on the questions, and to think about the current state of the debate. It is appropriate in general terms, and it is particularly appropriate because the International Law Commission study group was dealing with these issues just earlier this month, and will return to them in July and August, and therefore states will have the first opportunity to comment on the International Law Commission's, as it were, conclusions so far in the 6th committee later this year. So I think that this is precisely the right time to reflect on what the outstanding issues are before, as the states see the Commission's papers in 2 months. And finally, I will touch upon 2 very interesting aspects that the International Law Commission will be dealing next year: statehood and human rights. So, what are the issues? Why do we care about the sea level rise? And I want to introduce the political angle of the discussion by putting excerpts from two speeches on your slides from an event that took place just last week, two opening statements from last Monday from two figures well known within United Nations, Mr. De Serpa Suarez, United Nations Legal Counsel, who introduces the role of sea level rise in the political discussion, and Ms. Utoi Kamanu, High Representative, just until a few days ago, who again stresses the particular importance of sea level rise and also identifies in the first three paragraphs the somewhat uneasy tension between the challenges posed by sea level rise to islands and developing states, developing coastal states, and international law, which does not seem to be directly addressing these matters, or at least does not seem to contemplate these matters. So what does the science tell us? And I think I'm an international lawyer, but I think that on many of these matters, it is important for international lawyers plainly not to replace scientists, but to cognizant enough of the scientific discussion. My personal capacity as a member of the Water Convention's Implementation Committee, where I sit with scientists, I have found that that is a very helpful way of enhancing the legal argument. So it seems to me that the scientific consensus reflected in recent works by the Intergovernmental Panel on Climate Change seems to suggest that sea is rising, that sea level rise is accelerating, and that by the end of the century, the spread of the likely sea rise is between 43 and 84 millimeters, and the very highest even higher than a meter. So a proposition with significant implications for coastal states and particularly for island states. Now, what does international law give us in terms of tools? And I want to suggest three in particular. Two very familiar to international lawyers, as it were, the bread and butter of international law, and the third, a somewhat peculiar one. The first is negotiations, something that Article 33.1 of the United Nations Charter, when speaking about the peaceful settlement of international disputes, sets out as the very first one. And even if negotiations may be less flashy and spectacular than formalized dispute settlement, those of you who have dealt with the practice of international law will appreciate that they take care of 99% of the disputes. And one way of addressing at least some aspects relating to sea level rise is negotiation of boundary treaties and delimitation. And here I have put up an example of the coming from the Pacific Island Forum, that has been an organization very active in this setting, which has tried to nudge its members in the direction of concluding and delimiting boundaries, at least among themselves. So obviously, rights and interests of third parties is a different matter, but at the very least, among those actors directly affected, it seems that boundary settlement is thought to be a desirable direction. Obviously, an obligation to negotiate does not suggest an obligation to reach a particular conclusion, but still, that is an important point to consider. The second forum is also something very familiar for international lawyers, and that is a judicial settlement or other formalized settlement, an argument that can come up a little bit less predictably in any setting, And the example that you see on the screen from the Bay of Bengal case actually demonstrates that these are not new issues. It comes from an award from 7 years ago, initiated a decade ago, and that is something that courts and tribunals will, of course, deal with as and when they arise, and in doing so, they may establish important propositions of principle. For example, the proposition in paragraph 217 is something that states have very much relied upon in discussions. The proposition that climate change does not affect established boundaries. And again, of course, that is the normal way for international law to work, states building on judgments to formulate their position and shape state practice. The third setting is slightly less usual one, although of course very familiar from other fields of international law. And that is discussions in three international settings. The first is non-governmental, international associations, Committee on International Law and Sea Level Rise. So far, its last product was in 2018 Sydney report, influential in setting the tripartite frame that the International Law Commission later adopted on the topic. And at the very bottom, you see, sort of one might say, at the other end of the spectrum, the classic interstate discussion within United Nations, the open-ended informal and consultative process that took place last week, again, very helpful for generating state practice. What we have in the middle is International Law Commission that has created a study group on sea level rise in relation to international law that have issued the first issues paper that was supposed to be discussed last year, but due to COVID is just being discussed this year. And Caribbean community, CARICOM, was very actively involved in setting up the study group, intervening in the sixth committee in support of this proposal. Now, what are the issues identified in the issues paper? And just to give the background, so far, that is something prepared by the co-chairs. So we do not know yet what the study group more generally, what the International Law Commission more generally thinks about it. But it's certainly a very lengthy, a very detailed paper that provides much food for thought and a great collection of primary materials as well. So the first question that the report considers is the possible legal effects on the baselines and maritime spaces of a sea level rise. And here you have the map that I have taken from IUCN. I'm sure that that is something that we have all seen in the first classes of law of the sea. You have a very standard maritime map, entitlements being generated from the baseline, natural resources in the shelf, fisheries in the exclusive economic zone, land dominates the sea. But the question is, what do we do if land departs? Do maritime entitlements similarly travel landward? And this is what the balanced view that the study group suggested. And just as in parentheses, the study group adopted a rather, I think, an approach that could be rather convenient for the readers and for practitioners of having rather lengthy discussion, and then at the end of each section, having long paragraphs that have lots of subparagraphs in which the argument is summarized. And so we'll be particularly focusing on them. So ILC study group co-chair's point was this. First, UNCLOS did not consider in its framing the possibility of sea level rise. And therefore, the default rule is ambulatory character for baselines. If sea moves in one direction, that is where the baseline is set. If sea moves another direction, that is where the baseline moves to. And some states, United States is probably the more obvious example, take this proposition seriously and regularly review the baselines and, if need be, modify them. That does not respond to the needs, to the concerns by states, particularly small island states. What International Law Commission identified as an interesting development in practice, and that it felt that UNCLOS does not provide for, but neither does it prohibit. So I think that there's that interesting, from the perspective of Lotus, something that is not required, yet something that is not excluded. The deposition of notifications that state the baseline at this point and explicitly say that they will not be updated even if a sea level rise does occur, with the intention of protecting the entitlements of the coastal states. What is the reflection in state practice? And let me just say that the underlying and the highlighting are all mine. I just did that to bring out some of the issues that I am alluding to. Well, it seems that there's quite a lot of practice coming out of the Southern Pacific, particularly driven by the Pacific Island Forum, with, as I have highlighted, a similar trend from the Caribbean, but very little otherwise. So I think that there are 2 points to note here. The first is the very interesting way in how the study group frames it. It is a rule that is neither prescribed nor is it prohibited. In a way, UNCLOS is agnostic to such a rule in the framing of the Commission. That is an essential aspect for the argument to be successful and accepted, because in the discussion in the 6th committee, there was complete consensus that the constitution of the oceans need not be tinkered with. UNCLOS and the balance that is struck in UNCLOS has to stay. So the question is whether it's possible to address the issue without prejudice to the balance struck in UNCLOS. So that, I think, is interesting framing, and it will be interesting to see what states make of it more generally. There are certainly states that are extremely supportive, like the island states. If that is accepted, that is, I think, a rather elegant way of sidestepping the so-called Baxter paradox, the question of how to generate customary law regarding an issue covered by multilateral treaties. You know, the classic puzzle: if United States is the only country that is not party to the Convention on Rights of the Child, does it mean that customary law on rights of the child can be generated only by United States? So there are some interesting theoretical questions, but because of the shaping of the study group, it seems what they are saying is that practice of both parties and non-parties can be addressed at this rule. And of course, it will be very interesting to see what states say in the 6th committee. I think that this autumn 6th committee will certainly be something to watch. The second point can be put more briefly, and this is this: is the sea level rise going to affect the current maritime delimitations? And the answer, the study group says, and I think rightly, having reviewed the primary materials and submissions, is no. Bay of Bengal is good law. States have endorsed this to the extent, of course, that the particular instruments do not provide otherwise, which makes perfect sense. States can always depart from the default rules. Now, what about the effects of sea level rise and possible move of entitlements? And here I have again brought up the map to sort of remind the basic point that there are certain rights that exist within these limits. So within exclusive economic zone, there may be fishing rights and other rights. If the entitlements move, the coastal state no longer has a right, for example, to sell fishing rights. And this is the point accepted by the study group, and study group notes that that is a problem. That is one reason for perhaps for supporting development of international law that does not result in such effects. And also, I think, if we think about the overall balance struck, a reminder that there will be some who benefit from it. the development of rules that crystallize existing boundaries, even if sea level rises, is to the benefit of overall stability and the benefit of coastal states. But there will be benefit to third states if unpredictable, if the boundaries do move. So I think that is likely the type of balance that is going to shape the perspective of states. And again, it is very interesting to see how those issues will develop in practice. And there are also interesting questions regarding islands, but I think that is a whole other discussion. There is some disagreement about the lines between islands and rocks regarding sea level rise and regarding others. So I think that is perhaps I can leave for another day. I believe I have 90 seconds. So let me just summarize things that sea level, that the study group did not yet address, but will be addressing in the second issues paper. Statehood and human rights. On statehood, there is less universal support that is something that needs to be addressed. And the question that the Commission would consider is whether the disappearance, the total submergence of islands is compatible with the classic proposition that states have to have control over some territory. And of course, I think that there are ways of thinking about it, and some of them are outlined by the International Law Commission, certainly something that is likely to touch upon some of the hardcore questions of sovereignty and fundamental issues of international law. And I would imagine no less controversial would be question on the human rights perspective regarding migration and obligation to protect people fleeing from climate change. And there are some interesting developments in that regard coming from universal human rights organs. In short, one of the challenges facing the international community, and one to which one hopes international law and the International Law Commission will be able to provide some help and assistance. And that concludes my presentation. Many thanks, Professor Vasiani.
Thank you very much, Dr. Paparinskis, for your thought-provoking and detailed presentation. You're able to overcome the time constraints very well. And you have brought us new insight into how the International Law Commission may be approaching the question of sea level rise. I'm sure we'll have questions at the end for you as well. Speaking very briefly now, I'd say I note the challenges in respect of the law of the sea, but I am very curious about your views in relation to human rights, and in particular refugees or persons who have to migrate from their territories because of sea level rise. But we can come to that in a little while. Thank you very much once again. Our next presentation will be by Dr. David Berry, and it will be on the general issue of marine biological diversity in areas beyond national jurisdiction. And he has a specific topic, which is unity or diversity in the deep blue, choices in institutional design for marine biological diversity in areas beyond national jurisdiction. So Dr. Berry teaches and publishes in the areas of public international law and regional integration law. In his international legal practice, he has represented Caribbean states before international tribunals, advised regional and international organizations, served as an arbitrator on an ICSID panel, and assisted Barbados and CARICOM with the United Nations BBNJ treaty negotiations. As was noted already, Dr. Berry is, of course, a former dean of the Faculty of Law at Cave Hill, and he is well known throughout the Caribbean for his outstanding work in international law. So Dr. Berry, if I may give you the floor.
Thank you, Professor Vasiani, for that kind introduction. And I thank the Mona Faculty of Law for inviting me to speak at this conference. And it's lovely to see so many friends in the audience. Today's talk will be on the proposed agreement under the United Nations Convention on Law of the Sea on the conservation and sustainable use of marine biological diversity in areas beyond national jurisdiction. I'm going to share my screen if they allow me. There you go. Okay, everyone should be able to see my screen. Now, the United Nations Treaty is in the final stages of drafting. And what I'd like to focus on today is an underanalyzed part of the treaty, its institutional framework. I apologize in advance if there are any sounds in the background. That's why I'm wearing the headset. They've decided to power wash the Faculty of Law today. What a wonderful coincidence. So in my presentation, I am going to look at the institutional framework in 6 stages. The first, after posing the challenge facing the agreement, I will look briefly at its scope, both from a geographic and subject coverage perspective. I will then look at the main focus of the agreement and the institutional models that could be used to achieve that focus. And then I will contrast 2 extreme institutional models before turning to the position currently adopted in the text. This position remains unstable, however, due to the large amount of bracketed text still remaining. As a result, for each organ I will be discussing, there remain different possibilities regarding strength and form, and I will contrast the stronger and weaker options for each organ. I will then hint at some of the reasons for these divergent positions, looking at a few of the underlying sources of disagreement before suggesting the way forward. So first, starting with the challenge. Any agreement seeking to conserve and sustainably use marine biological diversity in areas beyond national jurisdiction faces one major challenge. How can you govern an immense geographic area which is currently subject to limited and inconsistent regulation in a harmonized and effective manner? The next few slides will give us a greater appreciation for the difficulty of this challenge. First, let's consider the geographic area. If you look at this slide, which is derived from IUCN documentation, the areas beyond national jurisdiction, or ABNJ, are estimated to cover about 60% of the Earth's surface. ABNJ are deep, with an average depth of between more than 4 kilometers and maximum depth of over 10 kilometers, and they form part of a single interconnected world ocean. The ABNJ represents around 95% of the habitat occupied by life on Earth in all of its forms, and much less than 1/1,000,000th of the water column and seabed in ABNJ has been studied in detail. A sectoral approach, I will suggest, cannot address the multiple pressures on the ocean and the different ways that they interact. And just for clarity, the ABNJ is all of the deep blue areas on this map. So as you can see, a substantial part of the Earth. Now, why can't a sectoral approach work? Why can't we simply rely upon existing organizations to conserve and sustain the use of marine biological diversity in areas beyond national jurisdiction? As summarized in a recent publication by the Pew Charitable Trusts, and I quote, "A patchwork of international bodies and treaties manage ocean resources and human activity in areas beyond any state's national jurisdiction. However, these governance bodies vary greatly in terms of their mandate, which determines their geographic scope, their objective, the legally binding nature of decisions they adopt, and whether they regulate one or several activities. Their jurisdictions often overlap, but virtually no mechanisms exist to coordinate across geographic areas and sectors. Too often, this piecemeal governance approach leads to the degradation of the environment and its resources and makes deploying management and conservation tools, such as environmental impact assessments and marine protected areas, including marine reserves, challenging both legally and logistically." Now, some of you may ask, why is this relevant to us? Do we have any areas beyond national jurisdiction in the Caribbean region? Now, areas beyond national jurisdiction, as the previous speaker helpfully showed, fall outside of zones subject to coastal state control. This means with respect to the water column beyond each state's exclusive economic zone, or generally beyond 200 nautical miles from their baselines. In terms of the seabed and subsoil, this area lies beyond their continental shelves, which is usually beyond 200 nautical miles, but in some cases a bit further. Now, the seabed and subsoil, as perhaps gone into some detail by Professor Volterra speaking next, is directly subject to the jurisdiction of the International Seabed Authority. However, the International Seabed Authority does not have the competence to cover all areas of the proposed agreement, at least as of yet. Now, if you look at this map, you will see black lines running along the eastern edge of the Caribbean. This is the 200 nautical mile exclusive economic zone, and then two triangles in the Gulf of Mexico. And these are areas beyond national jurisdiction. So they do border upon some Caribbean states, but in any event, let me emphasize that the agreement's potential benefits to states do not depend upon proximity to areas beyond national jurisdiction. All states may benefit from marine genetic resources. So what about the substantive coverage of the agreement? Can existing organizations conserve and sustain use of marine biological diversity in areas beyond national jurisdiction? This map, published by the Pew Charitable Trusts, shows all international governance bodies with a high seas mandate, except those with global coverage. For example, the International Whaling Commission, International Maritime Organization, and International Seabed Authority. As noted by Pew, these organizations collectively cover virtually all high seas areas and overlap in many places. Although there are many examples of multiple organizations managing the same region, few mechanisms exist to facilitate communication or coordinate activities among them. In other words, although the geographic coverage is good, and you see this from the shaded and lined areas of the map, the substantive coverage is limited and not coordinated. Many of these organizations will only cover particular species of fish, not all fisheries or organisms within their scope. Now, as noted previously, most high seas organizations only cover a single sector, not entire ecosystems, and very few can adopt binding ecosystem management measures. This slide shows 6 such organizations, and you'll see already that the coverage is diminishing. There are vast white gaps in the oceans where organizations do not cover and do not allow binding ecosystem management measures. Now, it gets worse, and this slide, I think, says it all. The map is blank. No high seas governance organization has comprehensive cross-sectoral mandate to regulate conservation in areas beyond national jurisdiction. All right, but this makes my case for why a new agreement is necessary, I think well accepted at the UN at least. It's needed to ensure cross-sectoral coverage of all elements necessary for successful conservation and sustainable use of marine biological diversity in areas beyond national jurisdiction. Now, the agreement has been drafted to cover an agreed package of issues. And as you see from the slide, it's set out in a UN General Assembly resolution and is specifically noted to be a package, which in particular and together as a whole is to govern marine genetic resources, including questions on sharing of benefits, measures such as area-based management tools, including marine protected areas, environmental impact assessments, capacity building, and transfer of marine technology. Quite a bundle. Now, as can be imagined, the interrelationship of these elements is complex. Many are mutually dependent. For example, area-based management tools require an understanding of what needs to be managed, and so an environmental impact assessment will need to be done. Sharing benefits of marine genetic resources will require both capacity building and perhaps new technology, particularly for small island developing states. And I should note that all but one CARICOM member state, and that's Montserrat, are included in the list of small island developing states. Let us look at the proposed institutional framework. Now, there are 2 approaches that we see in all the negotiating positions, which lie at either extreme in terms of what institutional structure should exist for this agreement. And the 2 extremes are, on the one hand, creating a strong new global treaty body, so brand new, doesn't exist, or using a fully fledged existing organization, such as the International Seabed Authority. And either would have international legal personality, binding decision-making powers, several distinct organs, etc. On the other hand, we could use existing regional environmental fisheries organizations. Now, the former approach, creating a new fully fledged international organization, poses challenges because it will entail significant resource costs and also has the potential to undermine existing regional and international organizations. It also has the potential to, at least as seen by some states, limit state authority over areas beyond national jurisdiction. The latter approach, relying upon existing organizations, is unlikely to work. As suggested in the previous slides, most of the existing organizations are focused upon a particular sector, specific, for example, a specific type of fish, tuna, and even then do not cooperate fully with neighboring organizations. So what has the agreement done? It has, after many years of negotiation, the agreement appears to be moving towards a middle position. The draft text creates 4 organs, which are similar to those existing in multilateral environmental agreements. For example, the Convention on Biological Diversity also has, as you'll see here on this slide, a Conference of the Parties, a Secretariat, a subsidiary body on scientific, technical, and technological advice. That's the Convention on Biological Diversity, and a clearinghouse mechanism. And the clearinghouse mechanism in the CBD is the access and benefit sharing clearinghouse brought about by the Nagoya Protocol. All right, this brings us to the organs as set out in the text. Now, the challenge at for the negotiators at the next intergovernmental conference will be how to ensure that the final form of these organs is strong enough to enable successful conservation and sustainable use of marine biological diversity in areas beyond national jurisdiction. So the challenge is how to ensure that these organs do what the agreement requires. So we have 4 organs. I'll start out with the Conference of the Parties. Now, this could develop into a strong organ with effective decision-making capacity, including voting rules which allow majority decisions to be made where consensus cannot be achieved, firmly specified competences, and the ability to create subsidiary bodies. On the other hand, it could be hamstrung if everything is left to later negotiations. For example, if the agreed voting rule now is consensus, then further negotiations about the conference could be blocked by a negative vote or expression of non-consensus. Similarly, the scientific and technical body will serve an important role as a body of independent experts who provide scientific and technical advice to the conference. However, its effectiveness may depend in part on how clearly its functions and competences are defined in the treaty. If everything is left out of the text and is left for future elaboration, then attempts to make the body strong and effective may be blocked again by consensus voting rules. You'll see a pattern emerging here. The next organ is the Secretariat. 2 organs are possible here from the text, the bracketed text. First, create a new Secretariat specifically for the agreement. Secondly, utilize an existing body. Now, there are examples of both in international institutional practice. The concern with the first, the new body, is cost. Creating something from scratch is expensive. The concern with the second is independence. If you are literally hosted inside another organization, you may be influenced by that organization directly or indirectly. Now, the other issue is regarding external independence of the Secretariat. Will it be able to liaise with other regional and international organizations in order to try to ensure cooperation and harmonization, as would be optimal for such an agreement? Finally, with respect to the clearinghouse mechanism, this is envisaged to be an information sharing body organized through an open access web-based platform. Its strength, however, may depend upon those persons providing the service. Will there be a network of experts and practitioners helping with the clearinghouse and what they are able or authorized to do? Will they have specific functions set out and thereby at least potentially guaranteed by the text of the treaty? Will they be able to assist with capacity building and training so as to allow effective use of the clearinghouse mechanism? Now, as can be seen from this brief discussion, the actual shape of the institutional structure under the agreement could vary considerably depending upon what competences are given to each organ and which bracketed text is accepted or deleted. So why do these different views exist in negotiating delegations? Why is so much of the text still in square brackets? This slide highlights some of the underlying sources of disagreement that give rise to variations in the text of the agreement. And there are really three large issues, three elephants or whales, if you want to use a fish metaphor, in the room underlying many of the arguments given by negotiators. The first is common heritage of mankind. And Judge Kathy Ann Brown has been a firm advocate of this in her writings. And I think that it's a very powerful principle, because what it does is it sees areas beyond national jurisdiction as similar, or at least the negotiators apply it and see it as ABNJ is similar to the area, the deep seabed area covered by UNCLOS and the International Seabed Authority. And the area is at least philosophically owned by all humankind. So in our conception then, do areas beyond national jurisdiction, are these areas owned by all of humanity, all people? Or the opposing view is that the water column above the deep seabed and subsoil is subject to high seas freedoms and therefore subject to exploitation by states and commercial organizations. The second underlying source of disagreement is level of development. Developed states are already accessing marine genetic resources. They are getting this information, they are using it to a certain extent, and they hope to profit from it. So they have little desire to limit access to these resources or regulate it more accurately, or share benefits. And finally, fishing. Further regulations of the areas beyond national jurisdiction might affect fishing rights. Strong fishing states have expressed concern and are trying to limit the effect of the agreement upon fisheries entirely. Two other issues also underpin negotiating stances. The first is funding. I think there is a consensus amongst all states, all negotiating parties, about costs being a concern. All parties, all negotiating states are concerned about the costs associated with a new institution. And there has been raised the idea of a light ABNJ agreement to save costs. And so you see a lot of states being fairly consistent in trying not to do very much at this new agreement in order to save costs. Now, whether that's a real position or whether that's one taken for strategic reasons is to be seen. Secondly, control. Some states wish to retain their current authority. They are already using existing regional and international organizations, and they have spheres of influence in those organizations. And therefore, if the ABNJ agreement uses those organizations, then those powerful states will have more power in those areas. Voting. Some states want more control, and so they would like unanimous voting or consensus voting. Other states would like the agreement to have more effective institutions, so they would be happy with majority voting, at least as a back possibility. Financing. Should the ABNJ agreement create a self-sufficient body? And we have examples in our region of trust funds and things like that. Or will it be one that is constantly fund seeking? And we all know the limitations of bodies that require constant funding and having to go to member states for top-ups. So what can we do to move the agreement forward? What positions should CARICOM member states take with respect to specific textual issues? And I should note here that in the negotiations, CARICOM states have been very strong, that CARICOM states and Jamaica, Barbados, many of the CARICOM states, Bahamas, all of them have sent highly qualified team to these negotiations, and they have been making their footprint is much larger than the size of the state concern. So what should CARICOM do when negotiating with respect to the agreement? The first thing I think to note is that we are at the final stages of negotiations. We can't start anew on some issues. We have to accept that there is a lot of water under the bridge, and make some compromises at this point and strike the appropriate balance. Secondly, we must be constantly reminded that all elements of the package are interlinked, and weaknesses in one area will affect others. And I recommend the adoption of the stronger versions of each of the existing organs, not as a cost measure, but as a guarantee to make the agreement effective. So there should be, even if consensus is the primary voting position, there has to be a secondary majority voting position to overcome any impasse generated by consensus. Secondly, competences and functions should, as much as possible, be spelled out in the text. If we leave this for later negotiations, then we may water it down substantially. The agreement must allow organs the ability to establish additional organs as needed. We cannot see forever into the future, and so it would be useful to have those powers. We must have the ability, the agreement organs must have the ability to coordinate with other organizations. The agreement will not be creating an all-powerful institution. It must liaise and use the powers and resources of regional and other international organizations. And then finally, we don't see this in the text, at least as a full-fledged organ. There has to be some sort of compliance mechanism. All right, that's all I can cover in the time allotted. I hope this has stimulated some interest in the topic. And I thank again the Mona Faculty of Law for inviting me to participate in the symposium, and thank listeners for their attention. Over to you, Chair.
Thank you very much, Dr. Berry, for your clear and precise presentation of an interesting topic. You seem to be quite optimistic about the prospects of the agreement in the near future. And perhaps in the question and answer, I would encourage you to elaborate a bit on your optimism, because you know there are others who would question whether we are as close as you seem to think we are. But thank you very much once again. Our next presenter, our final presentation, will be from Professor Robert Volterra, partner of Volterra Theatre, London. And he will be speaking on deep seabed mining and the International Seabed Authority. Professor Volterra is a partner at the Public International Law Specialist Firm, as I said, of Volterra Theatre, and a professor at University College London. He advises and represents governments, international organizations, and private clients around the world on the full range of public international law issues. He regularly advises and represents governments on the law of the sea, including as counsel and advocate in cases before the International Court of Justice. Professor Volterra has just crossed the Atlantic from Jamaica back to the United Kingdom. So I'm very much hoping that he will be fully awake and present for his presentation, which, as I say, is on deep seabed mining and the International Seabed Authority. Professor Volterra, sorry we couldn't meet you while you were here, but there will be other times. Welcome. The floor is yours.
Well, thank you very much for the introduction, Professor Vashiani. And yes, you're right. A great irony. I was last week, or until yesterday, in Kingston. Always a delight to be there. I was with a client, a government from out of the region, and we had intergovernmental negotiations. And it was a pleasure to be there, and very sad that I couldn't, just by coincidence, be staying on in person to meet with you all and enjoy the wonderful intellectual richness of this symposium in person. My thanks to Dr. Shazida Ali, the faculty at Mona, and to you, Professor Vashiani. It's an absolute delight to be on this panel talking about these issues. I believe my friends at Mona on the IT side are going to share the PowerPoint presentation for me. That's great. Thank you very much. And this will help me be able to look at my notes, which are electronic on my computer. I'm going to make a few introductory comments, and then I'm going to turn to my PowerPoint slide presentation. So for the moment, until I say the word slide, I'm going to be speaking without reference to the slides, but in referencing the background. And I thought it would make sense before getting into the discussion of legal issues related to deep sea seabed mining, looking at the International Seabed Authority and Law of the Sea Convention, to look a little bit about deep sea mining just as a technical phenomenon. Deep sea mining is defined as retrieving mineral deposits from the deep sea, and the deep sea seabed is defined as areas of the ocean floor below 200 meters. And essentially, there are three different areas of the ocean seabed where deep sea mining can take place. One is hyperthermal vents. Hyperthermal vents tend to be located at depths of 1,000 to 4,000 meters, very deep. And these vents, of course, are releases of very heated materials from deeper and below the Earth's crust. Then there are seamounts. Seamounts are the sort of accretions of high intensity valuable minerals that tend to be located at depths of 800 to 2,500 meters. And then there's the deepest possible mined areas, which are the abyssal plains, the deep bottom of the seabed, located at depths of 4,000 to 6,000 meters. And it's on the abyssal plain that the famous, what are called polymetallic nodules, these almost egg-type features sitting on the abyssal plain floor, are located. And it's where the exploration of the deep seabed mining potential is already taking place. Now, this deep seabed, as the various categories are identified, are located sometimes within areas of national jurisdiction. So sometimes either within the exclusive economic zone or the outer continental shelf of individual states, or in the common heritage of humankind, which is governed by the International Seabed Authority and UNCLOS. And I'm eventually, very soon, going to turn to that International Seabed Authority deep seabed to talk a little bit today, but I just wanted to give this slightly overview so that you don't think that it's only the common heritage of mankind, the area under UNCLOS where deep seabed mining can take place and exploration is taking place. There are three types of mineral deposits that tend to be found on the deep seabed mining, and that's certainly commercially what is interesting miners. There are polymetallic nodules, polymetallic sulfides, and cobalt crusts. And polymetallic nodules just means they're the egg-like accretions. Polymetallic just means multiple types of minerals. And a typical polymetallic nodule sitting on the abyssal plain in the deep seabed would contain manganese, copper, nickel, cobalt, lead, zinc, iron, and then things like lithium, titanium, and other very, very rare metals. And they're all concentrated there in one area, and that's why they're of great interest to commercial mining. Polymetallic sulfides are formed over thousands of years through hydrothermal activities, and they're the ones found near the hydrothermal vents coming up from under the Earth's crust, and they tend to have a lot of copper, zinc, silver, gold. So slightly different types of minerals that are coming out of those deposits. And then cobalt crusts contain cobalt, but also have manganese, nickel, copper, and platinum, and rare earth metals. So you can see these types of mineral formations and accretions in the deep seabed, on the deep seabed, and under the deep seabed present enormous potential. And that's why, despite the costs of mining so far down under the water, they're of great interest. Now, it's important to keep in mind that deep sea mining is currently only in the exploration phase. There are no excavations, certainly not commercial excavations taking place yet. There's just exploration going on. So it's in an early stage of human technology. The country that seems to be closest to engaging in deep seabed mining, actual mining on a commercial basis, is Japan. They've been doing a lot of exploration on their own continental shelf. They had successful extraction projects in 2017 and 2020, and it seems that Japan is about to commercialize deep seabed mining on its own continental shelf. In terms of the area, the common heritage of humankind, the ISA, International Seabed Authority, has granted only 30 contracts, and each of them is a 15-year contract, and they're only contracts at this stage to explore. They are not yet issuing contracts to extract. So that's quite important. So now we will turn to with that background, we will turn to the PowerPoint presentation. So we can go to the next slide, please, and the one after that. And this is what the outline of my talk is going to be over the next minutes that I have to me. I'm going to talk a little bit about what is the area, talk a little bit about the actors in deep seabed mining, look at the licensing regime governing deep seabed mining in the area, that's the area beyond national jurisdiction, and then look at some of the liability and dispute settlement provisions for that kind of mining, because anyone who is involved in any way in mining activities knows that they inevitably, like large-scale construction, give rise to very significant disputes that have to be resolved while the commercial operations are ongoing. So these are very important. Next slide, please. Turning to the area, next slide. The area is defined in the Law of the Sea Convention, and it is the common heritage of humankind. And I'm not going to repeat too much. I'm sure everybody on this session knows what the area is, and the fact that the licensing for exploration and extraction is done by a United Nations body, the ISA, International Seabed Authority, and that a certain amount of the proceeds, revenues resulting from extraction from deep seabed mining in the area are intended to go to a common fund to be shared by all the peoples and nations of the earth. Next slide, please. I mentioned the International Seabed Authority. It's, of course, located in your very own Montego Bay in Jamaica. And it is the body that is governing the commercial use of the seabed beyond national jurisdictions. And I will talk a little bit about some of the things it's done in preparation for beginning activities. It's begun drafting a mining code of conduct. It's looking at environmental issues and other things, even while there's no extraction actually taking place. Next slide, please. All right, so I'm going to look at the actors that are involved in deep seabed mining. This is defined in UNCLOS, and it is intended that the entities involved in deep seabed mining in the area are going to be commercial entities. It is specifically anticipated that these are going to be not governments, not international organizations, but commercial entities. And obviously, during the negotiation of UNCLOS, there were different points of view being presented by the negotiating parties. The reality is that only private enterprise has the sufficient technological advancement to drive forward the commercial actualization of resource potential on the deep seabed. But as many of you may know, there are a number of consortia, commercial entities that have licenses from the ISA to engage in exploration on the deep seabed that include government entities or government interests. So it's not exclusive of governments, but it is recognizing the reality that it's meant to be commercially operated extraction. And every time one of these commercial entities wants to get a license, either for exploration or extraction, they have to have a state sponsor. There has to be one state that's a member state of the Law of the Sea Convention and the ISA that sponsors the activity. But very interestingly, the sponsorship of the activity is anywhere in the area. It doesn't have to be near to the state in question. It doesn't have to be an area of the deep seabed that abuts onto the continental shelf of any state in question. And for example, Switzerland, as and when Switzerland is a party to the Law of the Sea Convention, Switzerland, even though it has no coasts, could, if it wanted to, license or apply for sponsor licenses for deep seabed mining activities. And we'll have a look a little bit later very quickly about which states have been engaging in such sponsorship. But perhaps surprisingly and certainly disappointingly, there has been no Caribbean CARICOM country that has sponsored any commercial activity. As you can imagine, being a commercial sponsor would be as a consequence of commercial arrangements between the sponsoring state and the commercial entity, presumably involving some payment of royalties, and Caribbean countries and indeed CARICOM as a whole could be acting as a state sponsor for deep seabed mining, say, off the coast of Japan. There would be nothing stopping that, but it hasn't been done yet. But other countries have. For example, Britain a couple of years ago became a state sponsor for a commercial entity that got a license for exploration in the Pacific deep seabed. Britain, obviously, without any of its own territory out there. So it's the ISA that grants and regulates all of these activities. Next slide, please. The role of the ISA is set out very clearly in UNCLOS, and it has an overarching objective, which is to provide for an equitable sharing of financial and other economic benefits derived from the activities. Again, deep seabed mining, it's embedded in UNCLOS that this is a commercial, economic, and financial activity. It's recognized as such, and the ISA's role is clearly set out. And ISA is mandated to adopt rules, regulations, procedures to do this. And that is exactly what the ISA has done. And as I said, it's also prepared mining codes of conduct and so on. Next slide, please. I just mentioned the mining code, and you can see there are different mining codes for each of the three types of mineral resource on and below the seabed. That's why I mentioned nodules, sulfides, and the crusts. They're different types of mineral formations, and they have different mining regulations for each because they are harvested. They're explored and harvested in different ways. And these mining codes have so far been addressing exploration. As I said, there has not been any exploitation yet, and there is work by the ISA to prepare draft regulations for exploitation in the anticipation that exploitation will take place. And some experts are anticipating that exploitation may start as early as 2025 and certainly by 2030. And you remember I gave the description in the beginning of the types of minerals that are in these deep seabed mineral formations, all sorts of rare, precious minerals, rare earth. The anticipation is that there are hundreds of trillions of dollars worth of value on the deep seabed. Next slide, please. I mentioned the role of states. It's very clear under UNCLOS that concessions in the area are given out by the ISA to commercial enterprises. This is in, whether you like it or not, whether you're anti-capitalist or pro-capitalist, this is embedded in UNCLOS, so there's just no point in complaining about it. It's intended to be a commercial activity, and it's embedded into the treaty. So ISA awards licenses or concessions to commercial enterprises, which can include states, under the sponsorship of a state that's a member of UNCLOS. And as I mentioned, sponsorship is absolutely necessary. And for the life of me, I can't see why CARICOM as a grouping is not more active in seeking out the role of being a sponsor. Next slide, please. So I'm going to look now very quickly at the licensing regime. Next slide, please. So there is a particular regime. As I said, there has to be a sponsoring state, there has to be a commercial entity, then there has to be a plan of work, and it's very, very detailed. The plan of work has to be submitted by the sponsoring state on behalf of the commercial entity to the ISA. Very important, it includes environmental impact assessments, emergency responses, health and safety, training, environmental management, et cetera, et cetera. You can see them listed here. It's very detailed what is required. And then the ISA analyzes it. And if it is approved, a contractor is given an exclusive right to explore the area. And eventually, when they give out exploitation concessions, they will be exclusive for a particularly defined area. And so it's exclusivity. Even applying for one of these exploration licenses is very expensive. It's about $500,000 even just to apply. Then there's all sorts of environmental documents. There has to be supervision both by the ISA and by the sponsoring state, and the insurance has to be provided and so on. Next slide, please. Now, I made reference to deep seabed mining within national jurisdiction. It seems to me highly probable that the first deep seabed mining will take place within national jurisdiction just because it will be administratively easier, and also the depths, as you know, are generally shallower, closer to the shoreline of a continental landmass. So I imagine that probably the first deep seabed mining operations will take place on the continental shelf of various coastal states. And there are a number of states that are quite advanced. Looking at this, you can see them down here listed. And as I said, I think Japan is probably the closest to going to commercialization. Next slide, please. Yes, and I've made some specific references here to Japan. There's been a couple of successful extractions taking place, still on an exploratory basis. But in the last 5 years, this has been quite active. And I think that's why the Japanese are sort of at a stage to be well advanced of other countries. Next slide, please. Right, so then you get to the annexes of UNCLOS, and there was a 1994 agreement on the implementation of Part 11, ways and means to get exploitation as well as exploration. These are all set out. I'm not going to go into it in any detail, just to flag that they do exist. Next slide, please. Now, finally, I'm going to spend a couple of minutes looking at liability and dispute settlement. As I said, this is important. In any commercial mining operation of any kind, there are always disputes. There are always commercial disputes. They're part of the ongoing operations. They will be commercial disputes between mining companies and their suppliers, mining companies and their clients, mining companies and transport companies, mining companies and governments and government agencies that give out concessions and licenses and inspections. These happen all the time. They are regular. So quite sensibly, the Law of the Sea Convention embedded within it ways to deal with dispute resolution, and particular in relation to mining. And you can see that there are provisions specifically dealing with questions about how the ISA is operating or setting up rules and regulations. So that's conflicts between state parties in the ISA. And then there's provisions for dispute resolution for parties themselves, the commercial entities that are engaged in deep seabed mining. both including the disputes related to a contract and disputes between the ISA and potential and actual explorers and contractors. There are questions about liability. Indeed, there's a bit of a lacuna. If you analyze quite carefully the provisions of the Law of the Sea Convention, it's not clear if there's, for example, an environmental and human catastrophe resulting from a deep seabed mining problem. It's not clear whether the ISA is responsible, whether the sponsoring state is responsible, or whether the commercial entity is responsible. And each of them are able, as long as they do some minimum levels of due diligence and box ticking, to argue that they're not the entity that has responsibility for any catastrophe that results. And this is something I think it's going to have to be addressed through regulations at the ISA in due course, but I flagged that. Next slide, please. So interestingly, under the Law of the Sea Convention, there is a requirement for binding commercial arbitration. As I told you, I mean, this is unique in the Law of the Sea Convention. It's very unusual for international treaties. There are international treaties that contain this, but there is a binding obligation to have commercial arbitration for certain kinds of disputes under the UNSEA trial rules, which are generic arbitration rules. And these are between the interpretation or application of a contract between the ISA and the commercial entity engaged in deep seabed mining. Fascinating that the concept of commercial mining was embedded in the UNCLOS dispute resolution rules for deep seabed mining. And you can see that there. This reinforces the clear intention of the states parties of UNCLOS that deep seabed mining be commercial and viewed as commercial. Next slide, please. I talked a little bit about liability for the activities. The ISA is supposed to have liability in relation to many activities, which is why it's also at the same time empowered to regulate, supervise, and make sure they're conducted properly and be open to inspections. Next slide. A contractor, as I said, has a couple of dispute resolution options if there's a dispute about how the International Seabed Authority is conducting its activities. Next slide, please. One of them, if for certain kinds of disputes, is the Seabed Disputes Chamber of the Law of the Sea Tribunal. And I imagine that given that it will be the choice of the commercial operators engaging in the deep seabed mining, that they will probably, where they can, choose commercial arbitration, because they will be concerned that the judges on the Law of the Sea Tribunal will have no actual technical awareness of how mining, let alone deep seabed mining, takes place. Next slide, please. Then there's some liability for sponsoring states, as I've said, but that is limited if the state has taken what is referred to as all necessary and appropriate measures to secure compliance of the commercial entity with the license that's been given by the ISA. So it's another lacuna. The states don't need to do much to wash their hands of liability. Next slide, please. Next slide, please. Next slide. These are just setting out the different provisions. And then there is some liability for the contractor. But you can see it's very caveated and in favor of the commercial entity. So you see the contractor's liability for wrongful acts. So it's not accidents, it's wrongful acts, as we all know as lawyers, has a meaning. And the assessment of whether there's been wrongful acts and responsibility, account has to be taken of contributory acts or omissions by the ISA. So again, it's pointing to the ISA to have great responsibility. And of course, only the ISA can bring a claim against a contractor for misconduct. So it's rather a convoluted arrangement, the architecture of dispute resolution. Next slide, please. That brings me to the end. Thank you all for your patience. And I look forward to questions and discussions by the panel. And I presume we leave on our cameras for the panel discussion, Professor?
Yes, I think that's a good idea. Thank you. Thank you very much, Professor Valtera, for your presentation, which was very thoughtful and stimulating and raised a number of issues that I hope we'll be able to go through in our question and answer session. Thank you very much. You are nonetheless aware for traveling across the Atlantic in the last few hours. If I might start, I would like to encourage our persons to offer questions in the chat or in the Q&A online, and we will have Ms. Tamoy Campbell, the president of the MonaLaw Association, who will present those questions for us. So while persons are thinking about their questions, I'd like to raise a general question or a general set of questions for each of our panelists. And it's a question relating to methodology in international law. We have heard from Judge Brown about the Chagas Islands cases, but it seems to me that we shouldn't need 3 cases to tell us the answer to one issue, which is what are the rules that determine the self-determination status of the Chagas Islands. I mean, all the cases seem to be pointing to that. And the outsider looking on at international law will say, well, why did you need 3 cases for that? What is it about international law which pushes you to have 3 cases to resolve one question? And then to have an argument about whether each court needs to follow the other court. With respect to sea level rise, the methodological question I'd like to ask is, why do we rely on the 6th committee of the UN, the 6th legal committee of the UN, to address what is clearly a technical problem, which, if anything, is political in its implications? Why not have either a technical agency of the UN or the political committees of the UN look into this question, at least with contributions from lawyers? But here it is focused on lawyers resolving the question, and the lawyers will consult with others, when the person outside might say, well, why didn't you go to the technical people first? With respect to Dr. Berry's presentation, the method question I'd like to raise is, why didn't the states rely on the International Seabed Authority to consider marine biological diversity issues? I know there's a difference between the water column and the bed of the sea, but the two interact significantly with each other, and you had a structure in place which could have considered the marine biological diversity issues. They are all familiar with freedom of the high seas versus common heritage of humankind. Why didn't you rely on it? Why didn't states rely on them? And finally, in respect of my general question for Professor Valtera, if you were advising a state and the state said to you, we have been waiting for 40 years on the right to exploit the deep seabed, why should we now become a sponsoring state when, in fact, we still don't know when deep seabed mining will start, and we have not been involved in the development of the technology? This is a CARICOM state speaking. We have not been involved in the development of the technology. And we have waited for 40 years since the convention was opened for signature. And nothing has happened in practical terms. So why should we now be involved? What is it about international law which creates such a time lag between our expectations and the realization of deep seabed mining? So those are the 4 questions which I have tried to put under one umbrella. And if I could start with Judge Brown.
Thank you so much, Professor Bastiani, and I trust that you would just allow me to highlight the fact that Michelle Walker, who is a member of the Jamaican delegation, has pointed out that Jamaica has sponsored blue minerals. And I
Yes.
also want to highlight so that we are a sponsoring state. And I'd also like to highlight that Eden Charles was the special representative of the Secretary General for the enterprise. So it's not just private sector. The enterprise is supposed to mine on behalf of all humankind. That's why there's a parallel system of mining. And so I'll leave it there and get on to your question. And the issue why you have to jump around so many courts is the basic notion that unlike the domestic system, international tribunals are based on the principle of consent and freedom of choice. So even though under the UNCLOS we have a binding mandatory dispute settlement system, there are limitations and exceptions, particularly when it comes to well, maritime limitation doesn't apply there for the UK, because what the Mercers was trying to do was to, as you say, designate its sovereignty. But where would it take the UK? So when the UK established marine protected area, it thought, well, you know what? I'm going to take up an issue that who is a coastal state? Well, you know, if you're going to define the term coastal state, that's a very lightly veiled question for what is sovereignty. So you're not going to get a tribunal that's supposed to be determining law of the sea matters to venture a definition on who is the coastal state when you know there's a sovereignty dispute. The Mauritius couldn't take the UK to the ICJ to have a sovereignty dispute, but what did it do? It got the ICJ, it got the General Assembly to get an advisory opinion. And that advisory opinion was devastating to the UK's claim. And on that basis, you now have an ITLA special chamber of 9 judges ruling that, well, in fact, there was the only dissenting judge was the one nominated by Maldives. And they ruled basically in that an advisory opinion has changed the state of the law. And I say to myself, I'm not on that special chamber because it was formed before I joined. But you know, you say to yourself, what other decision could they make? Could they disregard the ICJ advisory opinion? And if you look at the multiple fora, some of the other cases I wanted to raise, for example, with the Mox plant case, where you had the UK and Ireland. Ireland was trying to find any place to take the UK to settle that issue as to the harm to the environment in the Irish Sea. If you look at all of these other disputes, what they try to find is a forum which is favorable to them. So you find that sometimes the swordfish, you can frame a dispute so that it's a trade dispute to bring it to the WTO if WTO trade rules favor you. If you think that the law of the sea rules are going to favor you, you try to bring it on the UNCLOS. So you have disputes going to WTO dispute settlement, although that now is in shambles, and on the UNCLOS to try and get a decision which favors your end of the argument. But every time you have to be looking at, is there consent to the jurisdiction of that tribunal? I mean, on the UNCLOS, Article 287 gives you 4 different tribunals to choose from: the ICJ, full ICLOS, Annex 7, or Annex 8. So the issue of choice, which is so fundamental to safe sovereignty, is why you find this growing multiplicity of disputes, because you cannot get one forum to which a state has decided to give consent to decide all the issues before it, and that becomes troublesome.
Yes, what does it say about the rule of law in international affairs? If each state goes forum shopping to find the court that will give it the decision it wants.
It means that we're becoming more like the domestic situation.
All right. Okay.
From country to country.
Thank you, Judge Brown. Dr. Paparinskis.
Thank you, Professor Bastiani. So the question that you posed was whether we should think of sea level rise as a properly lawyerly question, and whether we should rather seek solutions with, as it were, technicians and politicians of the international legal order. And my answer is that it seems to me that it need not be either or. International legal process is a decentralized one, so perhaps there's a little bit of the theme carrying on from your discussion with Judge Brown, that international legal society is a very pluralist one, and political and juridical authority is located in a decentralized way. And it seems to me that it's not the case that states are just looking at the legal issues. There are, in the informal consultative group, we have the political discussion. In the Intergovernmental Panel on Climate Change, we have the scientific discussion. So it seems to me that states took the view in the 6th committee that there is an added value for an analytical, lawyerly view that cannot be gained in either setting. And the added value, I wonder whether it might really be by sharply posing the question, it would enable a quicker generation and, as it were, accretion of state practice in that regard. To the extent that one imagines that many states, particularly coastal and island states, will be reading with great interest the International Law Commission's views in 2 months, preparing for the 6th committee. Essentially, within 2-3 years, one could have a sense of what a significant part of the international community thinks on the matter. And to the extent that many states, particularly island states, take the view that this is not one of those topics like treaties or state responsibility, where one could approach them in a rather relaxed manner and wait until eventually consensus is arrived at, it's important to speed up the legal process. And that seems to be an argument that persuaded enough people on the 6th committee, or at least enough people were persuaded and enough people felt that they don't feel majorly against it, which is, I suppose, as far as we can get to agreement in the, again, famously pluralist society. Yes. Thank you.
Okay, yes. Thank you very much, Dr. Paparinskis. Dr. Berry?
Thank you. You asked me a question that has been troubling me during the negotiations, which is why didn't states rely upon the International Seabed Authority to consider the agreement issues? Why not use the existing structure? And as I showed in my slides, that one of the 2 possibilities for the agreement is to create a brand new structure or use an existing structure to fulfill all the, and then the other opposing view is to use the regional, sub-regional structures. I think there are various ways you can answer it. I mean, you could say that when they first started these negotiations, which started with ad hoc working groups and things like that in 2004, so roughly 17 years ago, all the issues were not very clear. And so what you would need to administer the treaty was not clear as well. And that as things evolved, then it became clearer and clearer as it went on. The second one, which I've heard, because during discussions, you hear states raising objections because some states have actually formally proposed the International Seabed Authority as the entity to cover the agreement. And it would, in one sense, it would make sense because it already has global competence. It already has an existing structure. It already knows very well, as you mentioned, the common heritage of mankind, the deep seabed area, et cetera. But the concern was about capacity or competence, because the International Seabed Authority is seen to be an entity focused on subsoil, seabed and subsoil, not upon the water column. So it would have to retool itself to start thinking about the water column, although it has done certain work on environmental issues related to deep seabed mining. But the other thing is, I think the more philosophical position, and Judge Brown will understand this, is that the International Seabed Authority is founded upon the essential premise of the common heritage of mankind. That is the heart that beats the organ. There is a huge debate in the agreement and negotiations about whether the common heritage of mankind is the appropriate principle to apply in the water column that it covers. And some have said, well, let's strike a balance. Let's have, instead of common heritage, common concern of mankind. That's a ridiculous conception, but some have proposed that. And others just said, no, it's freedom of the high seas. And so those competing visions then attach in some extent to the ISA and its organs. Now, the final answer would be politics. States like to be able to determine where an organization will exist. International Seabed Authority already exists in Jamaica. So there might be a clawing for headquarters in another state. But Judge Kathy Ann Brown has been involved in this process even longer than me. And so I'm sure she could give an equally detailed and perhaps better answer to your question. Thank you.
Yes, but thank you very much for your answer, Dr. Berry. You have helped to shed light on the issue, which I think remains an issue for some people. Professor Valtera.
Thank you very much.
Yeah.
Thank you very.
Go ahead. Go ahead. Okay. Judge Brown pointed out that there was that Jamaica was sponsoring one of the entities, one of the commercial entities, and this has indeed been announced in Jamaica. But it still doesn't change the impact of my question, which is if you're moving from 0 to 1, that's still not a lot. And what about the rest of CARICOM? So what in your view explains the fact that you, as you point out, that various developing countries in the Caribbean have not warmed to the idea of sponsoring entities? I mean, my view is that we are tired. We have waited for 40 years and have seen nothing happen. And it therefore reflects badly on international law. But I would appreciate your view on this matter.
Well, thank you very much, Professor Vashiani. And of course, the comments of Michelle Walker and Judge Brown are very well made and apropos. I had not actually, it's my bad. I hadn't realized that Jamaica had signed up and become a sponsor. I wasn't aware of that as a matter of fact. I was aware of Cuba, but it's really an old Comecon consortium driven by Russia. Cuba was brought in as a kind of a mercy to relieve Russia's foreign aid, direct foreign aid to Cuba. So it's sort of an add-on with Slovakia and Bulgaria and all that sort of thing in that consortium. In terms of the enterprise. The enterprise will come to exist possibly at some point, but its actual conduct and existence is uncertain and largely theoretical. The UNCLOS provisions require the ISA to act in the role of the enterprise in the initial stages of collecting information and that sort of thing, which is what it would do anyway. I mean, the ISA would do anyway. And then the provisions of UNCLOS very specifically direct that the enterprise must be operated in a commercial way. So very clearly the provisions of section 2 referring to the enterprise says, and I quote, "The enterprise shall conduct its initial deep seabed mining operations through joint ventures," right? So joint ventures with commercial entities that are getting licenses for exploitation. So there's an obligation for the enterprise to operate on a commercial basis. Indeed, before the enterprise is allowed to operate independently from the Secretariat, it has to engage. It's right in the text. It has to engage in joint venture operations that are evaluated by the member states and the Council of the ISA to, quote, accord with sound commercial principles. I mean, so it's quite clear that the enterprise is not a charity and it's not a benevolent organization. Its revenues may get shared in different ways, but it is intended very clearly, without a shadow of a doubt, expressly obliged to operate in a commercial way in joint ventures with commercial enterprises, certainly in the original stages. So the comments I made remain the same. So this then leads in very nicely to the question you posed, which was why haven't CARICOM states been more active? And fantastic that Jamaica is. I'm not terribly sure, because this is an area, giving out sponsorships for these licenses, quite frankly, it's a little bit like being a flag state of convenience for ships in maritime law. You know, we all know Liberia and Panama make hundreds of millions of dollars every year by giving licenses to ships. Liberia doesn't really have its own shipping industry per se. It gets free money by being a licensing entity. And I don't know why CARICOM as an entity or Caribbean countries, of course, Jamaica aside, which is fantastic news, have not stepped in to see an opportunity, quite frankly, literally an opportunity to get regulatory money for sponsoring commercial activities that don't have to originate in their own countries. So Nauru has done this, Tonga has done this, but all the other licensing, except for Jamaica, which is fantastic, is coming from European countries, and then China and Japan. And I don't see there's any reason why Caribbean countries shouldn't get more involved. It's fantastic Jamaica is, absolutely no reason. And the reality is that, you know, with all respect to the idea of the enterprise, the real economic benefits that are going to come from deep sea mining, other than to the private enterprises that are going to be conducting it, are going to go to the states that engage in the sponsoring and essentially get a cut of the commercial activity. And why should the developing world not actively participate and get that economic benefit? Why should it just be, you know, the developed countries? I think it's great that Tonga is doing it. I think it's great Nauru is doing it. Fantastic to have learned today about Jamaica. And you know, I mean, as an observer who's a friend to the region and who's worked in the region for governments for years, I think this would be a great CARICOM joint initiative to be as an entity, you know, spearheading the sponsoring process, even if it gets individualized for the technicalities of UNCLOS. So I hope I answer your question.
Yes, indeed. I was thinking though that one factor was, or is, that there was a period when the full extent of the sponsoring state's responsibility for environmental matters was not clear. I think the ITLOS has now cleared that up, and that may well help to open things up a bit more. But
well, I think you're right. And as the codes have been produced by the ISA, you know, they've been reasonable. The obligations on the sponsoring states are reasonably formalistic.
yes.
And you know, it does seem to me that the architecture of UNCLOS puts the heavy burden of compliance and enforcement with the ISA, and that's probably where it should be.
Yes. Okay. Thank you, Professor. There was a question in the Q&A.
Yes, it's Herbie Mackenzie.
Herbie Mackenzie, yes.
And the question is, in this era of climate change, suppose there were such a high rise in sea level to permanently cover all the smaller islands in an archipelagic state like Jamaica, what would be the implications for that state with respect to its maritime areas under international law? And would Part 4 of UNCLOS 3 still be of any relevance?
Yes, that is a question for Dr. Paparinskis and sea level rise. Doctor?
Thank you, Dr. Ali. Thank you, Professor Vassiani. It is an excellent question. Thank you, Herbie. And it really is something that many states are thinking seriously about, and the International Law Commission as well. So you're absolutely right that, of course, for archipelagic states, UNCLOS provides for a special way for drawing baselines reflected in Article 47 of UNCLOS, where archipelagic states have then the sovereignty rights within those baselines. So to some extent similar to territorial sea, to some extent not. So certainly a much more favorable regime than if they were just drawing it around individual islands. Some countries have raised the precise concern that if the sea level were to rise and they had to redraw the baselines, they might find themselves in a situation where they're no longer satisfied the Article 47 required ratio between land and sea. That is something that has been raised by Maldives and Kiribati. And then the worst possible reading of the situation is that they would have to redraw the baselines, possibly under the general rules, Article 7 to 9 from UNCLOS, possibly lose completely the archipelagic state status, possibly have it significantly diminished, and the whole baseline drawing is on its own not a cheap and easy endeavor either. So that is one of the most significant concerns. And I think that sort of that is one clear example of the challenge that states are facing. UNCLOS does not directly provide for the matter. It seems to be saying that if land departs, then sea entitlements are lost. This is something that only to a very limited extent can be addressed, if at all, via boundary agreements with neighboring states, because that is something that fundamentally affects rights of third parties and their nationals. So the question is whether we can develop a regime of international law that to some extent freezes these baselines, even if the land from which the baselines are drawn no longer exists. So there is no answer that international law can give at the moment. It might give an answer, I suppose, in a technical way, that if the sea advances, the rights are lost. And the question, something that for which the next few years, I think particularly wholesaling around practice around the International Law Commission study group will be very important, is to see whether general consensus can be generated to support the freezing of baselines rule that Pacific Islands in particular are trying to put as a rule of international law. And again, law of the sea lawyers are, of course, very familiar with the way how customary law develops, from the classic examples of continental shelf, starting from inauspicious beginnings with President Truman and getting into general customary law and widely accepted treaty law within 15 or 20 years. It is possible, but equally it is not inevitable. If we take a formal lawmaking process seriously, we have to see which direction these things lie. And of course, if we go back to UNCLOS, archipelagic waters were themselves a result of balancing of very complicated interests. So it's certainly something that I think archipelagic states are thinking extremely seriously right now. So you're right to raise that as a key question. Thank you.
Yes, thank you. On the freezing point, I would have thought that an archipelagic state, having declared itself an archipelagic state, could over time claim that its waters are now historic waters. Or alternatively, they could argue that there is a legitimate expectation that if they followed the rules today, those rules would stay with them. The regime that they established using those rules could not be changeable, because it would be unfair. They are not the states necessarily that are responsible for the sea level rise. Sea level rise is an international community phenomenon. So why should they be penalized for the changes in the sea level? I think that an argument could be made.
Thank you, Professor Vassiani. I think that is certainly something that states need to states need to consider. And of course, as we know from recent dispute settlement activities under Annex 7, questions about compatibility of historical rights arguments with UNCLOS is one on which reasonable people and states might disagree. So I think it would be interesting to see how it applies in this setting. I mean, I think as I would have to reflect upon your second question. Of course, as a general proposition, international law is familiar in certain settings. I'm thinking of the Antarctic Treaty regime, for example, of something that has been compared to some extent to objective regimes, yes. Things that are less dependent on third-party rights. And I suppose that could be one way of framing it. I guess really the counter argument would be that to get there, one would have to, I suppose, challenge in what seems to be the moderate consensus view reflected in the study group report so far, that UNCLOS is agnostic on the movements and the rationale of movements for land. So that, I mean, that strikes me as a challenge that I suppose is in some ways that states could be wary of entertaining, because that seems to me more directly strike at UNCLOS itself rather than trying to tinker around the surrounding considerations. I think that there was one more point that I wanted to make, and I think it relates to state responsibility. And that, I think, is really the hard question. I think really how, because the normative intuition suggests that many of the island states suffering from sea level rise are precisely the actors who have least contributed to climate change. So there seems to be the terrible injustice that those who can afford least and those who have contributed least are going to suffer most. And I think the question is, in what formal lawyerly garb can one dress that intuition? And I think that is where the Pacific Islands are trying to frame it through the lenses of the specially affected states, something that International Law Commission accepted in its 2018 conclusions on determination of custom as a relevant consideration. And I know that there is many strong views on whether specially affected states concept favors traditional global north developed states, the whole nuclear weapons debate. But it seems to me that in this particular setting, it would reflect a sensible policy dynamic.
Yes. Yes, I was just going to respond on the matter of specially affected states by saying that there is the authority of the North Sea Continental Shelf cases, a passing remark, but still something that acknowledges the possibility of states arguing that they are specially affected. And I think the prospect of your entire country being destroyed is by definition being specially affected. All right, Dr. Ali, are there any other questions in the Q&A?
It seems to be a part of a question which says Article 287 of UNCLOS allows for forum shopping. I think it's meant to be a question.
Okay, I think that's for Judge Brown.
Yes, can you hear me? In fact, it's interesting that this point is raised, because it goes to what I had intended to speak on initially. And if you go down to what I'm showing you now on the screen, this goes to the original slides that I had intended to show. That's Article 287. Choice of procedure. And the issue is that when we were negotiating the UNCLOS, remember, this was just after the Southwest Africa cases, developing countries were totally opposed to the ICJ. They didn't want anything more to do with the ICJ. They wanted to create a new tribunal, ICLOS. Some developed countries were wedded to the ICJ, for example, the Netherlands, where the ICJ is based. And Soviet and some Arab countries were averse to any court at all. and wanted arbitral tribunals. So you had to have a choice. So the choice of procedure that is built into Article 287 is one that states can make when signing, ratifying, or sealing, or even subsequently. But once you make a choice, you can change it. But it means that if you have two states in a dispute, and say one has opted for ITLAS and one has opted for the ICJ, then you go to Annex 7 arbitration. It's the default procedure. Increasingly, what is happening is because arbitration tends to be more expensive, you find that you initiate Annex 7 and then they're coming to us for a special chamber. For example, the current Maldives, Maldives case began as an Annex 7 case, and then they request to be moved to ITLAS in a special chamber where you can form a special chamber to handle the dispute. Now, it was suggested initially that this is going to lead to fragmentation because all of these different tribunals and courts would interpret the Law of the Sea Convention differently. This is not the case. In fact, there's been a fairly consistent spread of in terms of the interpretation of the convention. I'd make one particularly important exception is that whatever you sign or ratify here does not apply to Part 11 dealing with the area. You must, if you are having a dispute under Part 11, you have to go to the Seabed Disputes Chamber of the ITLAS, which is a special chamber. It's a special tribunal within the ITLAS, which handles seabed matters, Part 11. So that you have a choice here, but that choice doesn't affect you. So no, it has not ended up really affecting fragmentation, and it also has not had an effect in terms of leading to forum shopping.
Okay, thank you. Thank you, Judge Brown. Dr. Berry, if I may ask, the Caribbean has been quite active, as you mentioned, in the ABNJ agreement negotiations. What do you think accounts for that? Other than your energy and the drive of the various persons in the Caribbean, what is it about this treaty which prompted interest?
Thank you, Professor Vassiani. I'm not sure what the origins of it were, but I think a lot of it is personal, that some of the Caribbean negotiators have been around for a long time, and they are very much aware of the issues. And I think that they have been able to, in a sense, respond to issues as they're raised on the floor very quickly, very efficiently. There is a widespread negotiating team made up of academics across the region, persons from ministries of foreign affairs, ministries of agriculture and fisheries, et cetera. So there is huge resources brought to play upon this issue. I don't know why states in the Caribbean decided it was so important to focus that energy, but the energy is certainly there. When you have 15 member states of CARICOM, I guess 14 voting collectively together, then that does have a power, it's a powerful force. And then of course, CARICOM also fits within small island developing states, et cetera. And so you're able to mobilize all these different groups. And I had the privilege of attending these side meetings by these different groups, and CARICOM's voice was definitely welcome. And it was strong. So I would credit the numbers issue, but also the attention placed upon this agreement by the member states and the hard work of all those who have been involved in it over the years. Thank you.
Thank you. Thank you very much. And Professor Valtierra, you have been active in various arbitral matters, and including the ICJ. What's your view on the fragmentation question? Do you think
I would agree with, I would agree entirely with Judge Brown. I do not see any fragmentation. There is in any judicial system, and I'm not saying that public international law has a system, but in national systems, there are developments, evolutions in the law, there are divergences. I'm a Canadian lawyer, and between some of the Canadian provinces, there are slight different interpretations of the law between in the courts, and we're supposed to have a national law at the federal level, for example. And in the United States, I know, I'm told, but we all know this happens, you know, that the circuit court X is much more liberal than the circuit court Y or whatever it is. So these slight variations, they don't worry me. They're just sort of nuances as law develops. And in any kind of adjudicative processes that don't go to the same individual or group of individuals repeatedly, there will be slight divergences. You know, right now there's a European football championship going on, and there's more than one referee. It's not just one referee doing all the cases, right? And yes, there's some slight divergences. In one case, a nudge gets a yellow card, and another case, a nudge gets just a whistle, and another a nudge gets nothing. It doesn't mean that the world football is about to fall apart, or that there's no coherent rules to apply to football. It's ridiculous to say that. So I'm entirely in agreement with Judge Brown. Absolutely right. If you look at these cases, all the law of the sea type cases from earliest days onward, you see some development in the law. You see ideas intellectually being picked up, brought from Annex 7 arbitrations into ICJ, from ITLOS into Annex 7, back and forth as law and practice develops. But this is healthy, and it's not resulting in fragmentation in any way whatsoever. And I think Article 287. Yes, it specifically allows forum shopping, but not in some, pejorative sense. It's clearly there. It's in the treaty, and in fact, it's designed, as Judge Brown quite rightly pointed out, it's designed to enable states to arrive at a mutual common agreement about how to engage in the dispute resolution process when they need to. And her example of cases having started out in Annex 7 coming to the tribunal, fantastic. That's exactly what these things are designed to do. Have a default, but then optionality, and if there's consensus, to move forward. So I agree entirely with Judge Brown.
Okay, thank you. Dr. Paparinskis, I had promised that I would ask you about refugees. Do you think the Refugees Convention should be amended to take into account persons who are suffering from climate change consequences as they move from one place to another, including sea level rise?
Thank you, Professor Vassiani. Well, I think it would probably require a person with a more optimistic judgment about the general mood of the international community to suggest that it would be easy to amend the Refugee Convention in the direction of expanding protection. So I think I'm probably more in the company of those who would look at thoughtful application of the general rules that are out there. And I think that two instruments, or rather two documents that seem to me going in the right direction are one that I had in the presentation, the reference to the Human Rights Committee's decision of early last year in Te Ota and New Zealand, that recognized in principle the possibility of the breach of ICCPR by a person from Kiribati, but not finding it on the circumstances, but also two very powerful dissenting opinions in that regard. And secondly, a very interesting document produced by UNHCR at the end of last year, called somewhat long-windedly Legal Considerations Regarding Claims for International Protection Made in the Context of the Adverse Effects of Climate Change and Disasters. So it doesn't roll off the tongue easily, but what UNHCR argues, and I think plausibly, that it is possible to apply the general refugee definition that we have in the Refugee Convention and then apply the fear of persecution, in particular the causality, in a way as to give effect to protection of people fleeing from disasters. And on the at least my take on it is that in a way, it's perhaps, it is something that is the recipe for things that are likely to be accepted, because I can see how nobody would quite like it. Neither those who would like a broader coverage for a particular category of climate refugees, nor those who would like a more conservative, non-evolutionary reading. So it seems, the things that succeed in international law is that are equally disliked by all groups. And I think that this seems like a plausible formalist argument that could be attuned to these matters, and I could see how it could be received by, as it were, as we always have to see, can be got into state practice and judicial practice. And then methodologically speaking, that is something that could contribute through Vienna Convention Article 31.3b as subsequent practice in interpretation of the treaty,
Yes.
reshaping its content if there is consensus, at least in the judicial setting. So that is how I would think about it. I don't think that this is a century to open up the grand universal human rights treaties for amendments.
Yes.
Thank you.
And your comment about treaties over time, the subsequent interpretation, I'm sure Judge Nolte would like that analysis. All right.
Professor, could I just comment on that?
Jump in.
And I would have great concerns about proceeding in that way, because to put it very simply, it risks blaming the victims. The Refugee Convention identifies people for particular status of refugees with obligations on states to assist and protect and so on,
Yes.
where they are suffering from persecution in their home country. And that persecution has to come either officially from their own government or from the failure of their government to protect them if individuals are doing it. So it's the government of the country where they're living that is at fault. And that's why they're deserving of protection under the Refugee Convention. But most of the countries that are suffering from the sea level rise are not the cause of it.
Yes.
They are victims of it as countries and as peoples, and it's the developing world. So in fact, perversely, giving refugee status recognition under the Refugee Convention is blaming the victim, because the only way you can be under the Refugee Convention a refugee is if you're suffering persecution. Now you can broaden the types of persecution, you can make it different kinds of human rights violations, but the reason other countries are obliged to assist this class of people is because their home country is deliberately not protecting them or is deliberately abusing them. And so I'm very concerned that this would result in blaming the victims. So I just put that on the table. I think it would be grossly unfair to the developing world countries that are really being affected by this.
Yes, if you look at it that way, you're blaming victim governments. But
exactly, sir.
You
yes.
could formulate a way around that. But I take your point that it's pointing in the wrong direction. Yes. All right, Dr. Ali, are there any other questions?
I think there was one more, but it says, do we recognize that even different island groups may have different interests in how its marine resources are to be managed and protected? And there's some examples given from the Bahamas and Cuba, which I'm not sure you want me to read on. The Bahamas, for example, owes much of its economy to the pristine environment and the resources it harvests from its seabed. Cuba and the Bahamas has struggled for years with this territorial conflict, and indeed in one famous case, the shooting or sinking of defense vessel and death of Marines.
Okay, I'm not sure if it's a question or an observation.
I think it's more of an observation, yes.
Okay. If there are no more, I think it might be time for us to bring this session to an end. Dean, are there any others?
Yes. No, there are no more questions.
Okay. Well, I would like to thank all our participants. Judge Brown, thank you very much for educating us. Dr. Paparinskis, thank you very much. Dr. Berry, thank you. Good to see you as usual. And Professor Valtera, thank you very much, and hope to meet with you face to face sooner rather than later. I think this has been very helpful, and it has been helpful because all our contributors have brought strong intellectual prowess to the table, and we in the Faculty of Law have benefited. Thank you very much. There will be a publication arising from this symposium. So if you would like to put your various presentations in the form of an article for publication, we would welcome them very much. All right. It remains for me then to thank all our organizers and those who kept us running throughout our 2 hours and a bit, and to reiterate our gratitude to the various participants. Thank you very much.
Thank you, everybody. See you
Dean,
tomorrow at
is there-
9:30.
9:30. All right. Thank you. Bye.